All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All way of cause to plead. Draw near. Give attention. You shall be heard. God save these United States. Great state of Florida, this honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is Joseph versus the state of Florida. Counsel?
Good morning, Mr. Chief Justice, other justices, counsel. My name is Fred Susnick. I represent Mr. Joseph here. Feels a little bit strange to be in person in the courtroom. The last time I was not sitting at my
We can relate.
sitting at my dining room table was for the sentencing in Mr. Joseph's case. I'm going to address actually just two of the issues here. I think the briefs pretty much cover most all of it, and I'm not going to stand here and go over everything again. The first issue I want to address is issue number one, where the court did not exclude the testimony of the witness who was listed by the state at the last minute. And when I say the last minute, I don't mean a week before trial. I don't mean 2 days before trial. This witness was listed as we were picking the jury. The witness did the evaluation that the state had of the evidence while we were picking the jury. And this witness was disclosed to us as we were picking the jury. The deposition of him was done as we were picking the jury. At his deposition, he was listed as a firearms tool mark expert. His deposition was taken, as the record would reflect, and it became clear that the defense needed a witness to rebut him or at least tell us whether or not what he was saying was true. I went through the JAC requirements of having an order done and us looking for an expert, which was being done by other people because I was in the courtroom picking the jury with co-counsel. It became clear by the investigation that my investigator did is that we didn't need a firearm expert, we needed a tool mark expert. There's a difference. A tool mark expert is very, very specialized, and there are none. There are none in Florida that we could find on such short notice. The one we had moved to Tennessee or somewhere and said he wasn't ever coming back to the state of Florida. I did research. My investigator did research and got information on tool mark experts. We could not find one. This was all presented to the court. Some of the research is in the record, which was presented to the court, that this tool mark expert, which the state apparently needed for this case, otherwise they would not have done it at the last minute, would not have presented it. There seemed to be some concern on their part as to whether or not they had enough evidence to show that which weapon was used, that there was only one weapon used, and who used the weapon, as no weapon was recovered. A motion was filed and argued before the trial court judge in this case, asking for this witness to be excluded as it was disclosed on such short notice. She held a Richardson hearing and found that, in fact, a Richardson violation had occurred. This was a discovery violation. Yes.
Argument I take is going. In fact, I believe the judge.
That's correct, Your Honor.
Interesting. And but the argument is going to be that you were given an opportunity to hire an expert and somehow cover. Take the practicality of a trial lawyer trying a case involving the death penalty, serious assistance, taking the jury, being concerned about cross-examination, being concerned about everything that goes on during the trial, which is a lot. And at the same token, you're supposed to somehow be looking for someone, an expert, to be able to impeach the state's expert. What prejudice goes, other than just the fact that they were just giving that at the last minute, how does that affect your ability to properly defend a defendant in court?
Your Honor, it affects my ability to properly defend a defendant in court in that the state is now presenting evidence that I did not have a chance to thoroughly investigate using my expert to find out whether or not that evidence is proper, whether or not the evidence shows what they say it does, whether or not there's another expert out there who would contradict this expert, whether or not other tests can be done to this. These are all questions that would be done by a trial defense attorney, and questions I would do had they submitted a witness to me. They did not. And when the court asks, how is there this error? And the court's correct. I was quite occupied in other things and had been prepared for trial. This error is compounded. And by the way, I do find it interesting that I was asked if I'd like to use their expert on my behalf, which I turned down because it was their expert, and I needed my expert to tell me what he was doing was right. But the error is compounded, and that was part of my argument that I was going to get into further into the trial. The judge denied my motion to exclude the witness and said, we're moving on. She wanted to get the trial moving. They called their witness eventually at the end of the trial, and I was cross-examining him. During my time, whenever I could and whatever my investigator could do, I was reading and studying what toolmark experts do, what toolmark experts are needed for, what kind of evaluation, what kind of tests they do. And I was thoroughly cross-examining their witness. I forgot his name at this point.
Felix.
What?
I think his last name was Felix.
Yes, I think so. I was cross-examining him in great detail and asking him questions, and it was getting to the point where he was saying, yeah, other experts could differ with me. As a matter of fact, on page 1650 of the transcript, I believe it's where it started to say, yes, other people could disagree with me. There's other tests that can be done. My method may be not the way other people do. There can be contrary opinions. It was at that point on page 1654 of the transcript, on her own, without any objection from the state, the trial court cut me off, said, no more questioning. We're done with this witness. There was clearly more questioning. And that's relevant because as yesterday in the Sievers case, Judge Lawson asked a question of the defense attorney when you were talking about, I think it was a 2-hour videotape. Wasn't that videotape thoroughly questioned about, thoroughly cross-examined? Cross-examination was done on that, and you got every question and every answer you wanted on that. You didn't need that tape in. In this situation, no, I didn't. I was cut off from my cross-examination, so I did not get to thoroughly cross-examine their witness because the judge cut me off on her own motion.
Counsel, help me understand the exact relevance of this information. I mean, am I correct in understanding we don't have the gun that was used?
That's correct, yes.
So what is this? This is not matching a particular gun to these casings, correct?
That's correct.
So this is all about whether one weapon as opposed to more than one weapon was
correct.
used. Well, help me understand how that fits in with your theory of the case and the rest of what was presented. I mean, we know we've got evidence came in. I know you contest it, but evidence came in that your client was the shooter, correct?
There was evidence to that effect.
From two people, right?
Witnesses which we had objected to their testimony.
I understand. That's a separate issue.
Yes.
But assuming you don't win on that and contesting that, I'm trying to figure out how this really makes any difference and how this fits into your theory of the case.
It makes a difference in that the state's theory was that there was one shooter, one gun, and all this multitude of ammunition, slugs, casings that was all over the place came from one gun. They put this witness on to testify erroneously that only one gun was used, to leave an impression with the jury that only one gun was used, that this toolmark expert came in and said, all these casings, all these shells, all of these cartridges, all of these slugs, none of which were tested against each other, all came from one gun. They wanted to leave an impression with the jury that only one gun was used. That's why they called this witness. And their witness deprived me of getting the ability to come in and say, no, there might have been two guns. So this is what it was done for. That's how it's relevant. That's how it's not harmless. You know, as Judge Munoz said yesterday, you asked whether or not the jury had all the evidence, they could consider it and disregard what they didn't want. In my case, they didn't. The judge cut me off mid-sentence on her own motion and left the impression with the jury as a result of me stopping in the middle that there was one gun, all these cartridges, and there was a multitude of cartridges came from one gun. And therefore, there was one shooter, one gun, one defendant.
I struggle a little bit with the assumption that more than one gun would necessarily mean more than one shooter. It is certainly known to occur that a single person will use more than one weapon.
But as Your Honor pointed out, none of the witnesses said there was multiple weapons.
Well, but none of the witnesses said there was anybody else there, and none of the witnesses said anybody did it other than your client.
That's why they need to have all of the evidence in front of them to make that decision. Your Honor, there was a multitude of cartridges, more cartridges than, and more shells than could have come from one gun, possibly. So that's why it's relevant. That's why the judge...
Sometimes people reload. I mean, this is just...
But
there seem to be assumptions here that just kind of fly in the face of common experience and reality.
Well, assumptions are made when you're presenting evidence and the jury makes a decision when they've heard all the evidence. The problem here is you are saddled with certain assumptions because the state presented the witness at the last moment and the court cut off the cross-examination. So the court, I'm hard-pressed to say, oh yeah, I'm making this assumption that there might have been multiple shooters and I have no evidence, but you have no evidence because the state presented a witness that you couldn't rebut and the court wouldn't let you rebut. So yeah, yes, Your Honor, there may be assumptions, but that's why you should be allowed to present all of the evidence.
I mean, to a certain extent, I mean, if your defense says there was more than one shooter, more than one gun, I mean, isn't it incumbent upon you to, before trial, to come up with some kind of evidence and to be able to present evidence to that effect, or be prepared?
It's incumbent upon me to present evidence, if necessary, to disprove the state's case. At that point, there were a multitude of shells. There were a multitude of, they were coming in different directions. They were found in different places. That can be done by arguing the evidence, as was talked about yesterday in the Seavers case. I
Right,
can
and
argue that the evidence wasn't there. Sorry.
I'm not suggesting you have the burden of proof. Obviously, you do not. But to be able to properly cross-examine and test the state's case, it seems like that there's a certain amount you would be prepared to go without waiting on the state's case.
As the state said at one point in the transcript, the defendant went down, which would be, defense attorney went down and viewed all of the evidence. I did view all of the evidence. I knew all of the evidence they had. I knew what holes they may have in their case. It's not incumbent on me to correct the holes on their case and tell them where I'm going.
I think what the
and to make
question is leading
motions.
to is, at some juncture, you had an obligation to explain to the judge how this or this late notice affects your defense that you have planned. At some point in time, I think during the Richardson inquiry, which was done after jeopardy was attached, and that's what I think the judge asked you, well, tell me how this affected your defense. And I think that's the time when you got to tell the judge, okay, judge, this is major stuff. I mean, I plan to go this way. Now they got his expert says it's going that way, and I have no ability to or time to hire someone to come in and possibly contradict that. So did you inform the judge what your theory of the case was and how this affected your defense?
I believe I told the court that I needed an expert to evaluate the evidence, look at the evidence, and see if and how it would change. Once again, I can't tell the court how it would change my approach if I don't know what the witnesses are going to tell me. And it's at that point the judge said, well, just use their expert. So, Your Honor, the answer is it would change my preparation if their expert, if my expert came and said their expert was not giving me the correct information. You can't very well ask an attorney while they're picking a jury, as you say, jeopardy attached, well, how would this evidence that they just gave you that you don't know what the evidence is affect your case? I can't tell the court other than I need my expert to tell me if their expert will do something different so that it possibly changes my case.
Well, but isn't it true, though, that the purpose of an expert that you would have called on toolmark issues would have been to rebut the state's expert on toolmark issues, right?
Well, possibly it could have been to rebut it. Not only would it have been to rebut him, but it could also be to put in additional evidence that says not only what he did was
that,
wrong.
however, sounds like a different problem. That now we're in the country of things you might have noticed up, things you might have done. I'm saying that as a thought experiment, right? Let's assume that the state's toolmark expert is fully rebutted.
Yes.
As a matter of logic. Every word that person testified to is now.
Okay.
Help me understand how the theory of defense changes then. I share the Chief's question about how even if there is no evidence in the record that it is a single weapon, right? Let's just assume the state puts on no evidence about how many weapons are involved, relies on the testimony of the two eyewitnesses, the casings where they are, the slugs where they are, puts on no evidence that it's all from one gun. Help me understand how your theory of the case changes.
When Your Honor says it's fully rebutted, as Justice Munoz said yesterday, it's for the jury to decide whether or not to accept it or refute it. I don't know if it's fully rebutted. You don't know if it's fully rebutted. The jury is the only one that can determine whether or not it's fully rebutted.
But I'm asking just as a matter of again, it's sort of a thought exercise here. Let's assume that testimony all drops out. Assume they'd never called a toolmark expert. Assume this problem never arose from the standpoint of late notice.
Okay.
What I'm trying to understand is impact on defense. I'm trying to understand how it changes your position, how it ultimately prejudices Mr. Joseph.
Well, at that point, we don't know how the trial is going to go, but what we do know is that there isn't going to be a witness that said there was one gun. There's going to be a witness that says there's all these casings came from one place, all these. So argument can be made relying on the evidence that there is a possibility of more than one shooter by looking at where the cartridges are, where the shells are, how they're distributed. That would be for the jury to decide whether or not the state proved that there was only one gun and one shooter, which is why they brought this witness up at the last moment. They knew that that was a problem. That's how it changes. If that witness isn't there at all, the argument can be made that, in fact, they did not prove the distribution of these shells in the house, out of the house, how many shots came out of that gun, all those things. Was it reloaded? Could it have been reloaded? All those things are not there for the state to stand up during closing and say, my witness said this, and therefore that's it. And I had no witness to bring in to dispute that. And back to the refuted question, once it's refuted, any trial attorney knows that a jury listens to expert witnesses more than they're supposed to. No matter how many jury instructions you give them that say they're not anything more than an expert, you give them the as much credence as you think an expert needs, they're going to say their expert said this, and we didn't have an expert. I couldn't bring, once refuted, you've got to go beyond that to say, hey, this is what can be and wasn't. Any other questions on that issue? Your Honor, I'd like to address, the next issue I wanted to address was issue 14. It's just phase 2, I believe it's referring to the jury instructions and the jury not following the jury instructions on mitigating factors. The jury just didn't listen to the court's instructions on mitigating factors. They came back with a verdict recommending death, I believe, within 2 hours. The trial court, in her sentencing order, found several mitigating factors existed. She did say she wasn't going to give them much evidence or any evidence at all, but she found they existed. This jury found that not a single solitary mitigating circumstance existed in any fashion. It's clear they didn't listen to the court's instructions on what a mitigating factor is and what a mitigating factor isn't, and whether they should give it any weight. They gave none any weight. The trial court judge gave some of them weight. It's Mr. Joseph's position that they didn't care what the mitigating factors were, didn't listen to what the mitigating factors were. As a matter of fact, there are a couple issues which I talk about in my brief regarding heinous, atrocious, and cruel, and cold calculated, and premeditated, where the judge let in irrelevant evidence and evidence about prior statements made by my client, which I believe also affected the jury's instructions, but I believe those are clearly briefed, and my position is in the brief on those. But they didn't listen to the court's instructions, and when the judge did her sentencing order, she did, and she's found that there were mitigating factors. My position is, had the jury listened to the court's instruction, followed the court's instructions regarding the mitigating factors, and found that some existed but they weren't giving them any weight, it could have changed one juror's opinion. That's all you need to prevent a death sentence. So it's my position that they did not listen to the instructions, and this is shown by the fact that the judge, in evaluating the same evidence, found that there were mitigating factors. For those reasons, I believe that the death sentence should be overturned.
Counsel, you are in your rebuttal time.
I understand.
You can keep going.
I understand, Your Honor. In just a few short minutes, I say I have 8 minutes left. The only other thing I'd like to talk about is proportionality. Now, I know this court has said there is no proportionality, but at this point, I'd just like to give a nod to proportionality and ask the court to reconsider Judge Labarga's dissenting opinion and do a proportionality review of this case. This is not one of the most heinous, atrocious, and cruel or cold and calculated homicides that have occurred in the state of Florida. It's bad, but it isn't worth the death penalty. And I thank you for your time and attention. Thank you, Your Honors.
Thank you. Counsel?
Thank you. Good morning, Your Honors, and may it please the court, Rhonda Geiger on behalf of the state of Florida. I guess I'll just jump right into issue 1 and address some of counsel's comments with respect to that.
Let me just ask, maybe start you off on issue 1.
Okay.
Ms. Geiger. The murders in this case occurred on December 28, 2017.
Correct.
The defendant was indicted a month and a day later, January 18th, 2018. This case went to jury selection, began on February, right, and on February 23, 2 years and a little more than a month after the indictment, the prosecutor comes in with during jury selection with an amended witness list, providing them with an expert witness of all things. Now, if I'm reading the prosecutor's explanation to the judge during the Richardson inquiry as to why that happened, and she, like a good prosecutor, or he, went to visit the detective, as anyone who's done homicide cases would know to do, and go over all the evidence, and they're going over the exhibits, they're going over the casings, they're going over everything. And at the end of the discussion on the casings, the prosecutor asked, where's my expert report on these casings, on the ballistics report? And the lead detective said, there isn't one because one wasn't done. Now, this is the Palm Beach County Sheriff's Office, which has a humongous budget, and they have their own labs. They don't have to send it anywhere. So strings were pulled, and somehow the ballistics department got it done that day, and lo and behold, the next day there was a report. And that's when counsel got it. Is that pretty much the lowdown of what happened?
I think maybe we're off by one day, but yes, that's pretty much. I think jury selection began on the 14th, and the report and the witness were disclosed on the 13th. But
Okay.
yes, pretty much.
So that's pretty much what happened.
Yes.
And obviously it was inadvertent. It wasn't anything intentional. It's just things happen. So tell me then, I mean, how is it a ballistics report from an expert is an important issue in a trial? And this case was completely circumstantial. No one testified they saw the defendant actually shoot the person. Am I correct? People
Well,
heard the shots.
I guess if you take counsel's argument that the identification coming in through Detective Creelman was not substantive evidence, then I would agree with you, but my argument is that that is substantive evidence. So yes, we do have two eyewitnesses to the shooter.
Okay. So anyway, you had these casings in there, and their theory of the case, you know, as maybe a long shot or not, was that perhaps someone else was involved in the shooting. And again, that may be a long shot, but it yet is their theory of the case. How is it not prejudice for them to be, you know, struggling to go out there and find an expert to come in and testify while he's trying to pick a jury in a first-degree murder case where the state's seeking the death penalty?
Well, I think we have to cover a couple of issues, first of all. So I think we know it was inadvertent. I don't think there's any dispute on that. And the judge gave counsel every opportunity to explain that prejudice to him. She gave him an opportunity to dispute what she said about her, what the defense was. And I think her exact words with respect to his theory of the defense is, isn't it your defense? It wasn't my guy. One gun or 5 guns doesn't matter if your defense is, it wasn't my guy. He didn't have a theory of his defense. So, and he was given every opportunity to say that. Yeah, my theory is there was another person there. My theory is alibi. He didn't do any of those things. And I think what we have to look at is whether or not his defense was equally as viable with the admission of this evidence as it was without this evidence. And the fact is it didn't change anything. His defense was still, it isn't my guy, no matter how many weapons there are. And even if he thinks he could have somehow shown, which I don't agree with his categorization of Omar Felix's testimony. Omar Felix flat out said, I would expect another expert to come to the same conclusion as I did with respect to these 9 casings coming from the same firearm. So whether or not another expert would have said the same thing or said something different, that doesn't in any way impact his defense. And I think another thing that we have to shift to slightly is that exclusion of evidence is not a favorable remedy. Exclusion of evidence is the last resort. And so if we're going to back up from that and say this was disclosed pre-trial, and I think if you look at the case law, in general, when courts have found prejudice and have said that the judge conducted the Richardson ruling incorrectly, it's when this evidence was disclosed after the trial started. So the defense has already committed to something. The state won't be offering any fingerprint or DNA evidence. Oh, shoot, we have that evidence.
My question I have is here, I mean, typically the remedy when something like this happens right before trial, one remedy is to grant a continuance.
Sure.
and we'll
Yes.
try this case 6 months from now. Mr. Susnick, you go out and hire
He
your
was
expert.
offered that.
But the judge didn't deal with the Richardson inquiry until after the jury was sworn. So what are you going to do, send a 14, 15 people home for like 3 or 4 months and then bring them back?
She did specifically discuss the timing throughout this, and I agree, it would have been ideal if they would have handled it at the very
I'm not-
beginning.
She took the continuance option off the table once the jury was sworn.
Well, she took a lengthy continuance off the table, but again, she very specifically said, I will give you time to find someone. That is a quote. I will give you time to find someone. And I think this sort of plays into counsel's argument that there are no tool marks in Florida or anywhere. If there aren't any, no amount of time is going to give you a tool mark expert. So that becomes a little bit off the table as well. It's a little bit irrelevant. But Omar Felix is a firearms expert. He's not a tool mark expert. He specifically said that a tool mark expert is an umbrella term, a fire that will cover everything. Any tool that makes a mark on any object is a tool mark. So nobody's going to be just a tool mark expert. You have to narrow that down. You have to funnel that down to be, and so he's a firearms expert. So he knows how to identify the tool marks that come about with the use of a firearm. So, I mean, I think that's disputable as well, that he needed a tool mark expert. There's no such thing. You have to winnow that down. He needed a firearms expert, and there are many of those. So looking at twofold, if there aren't any tool mark experts, he's never going to find one. If he needed a firearms expert, there are plenty of those, and he in fact had one, and he could have found another one. The trial court said, we will make accommodations. I mean, that is a quote, we will make accommodations for you. And she said, I can't imagine you can't find one in 2 weeks. He had a 2-week period to do so. So all of that fails. He can't find one. It's incumbent upon on him at some point to say, I need some time. She could have adjourned for 5 days. That happens. Trial courts take breaks, admonish the jurors not to do anything in the interest of fairness. But the fact of the matter here is the trial court held an appropriate Richardson hearing. She made the proper determinations. She came up with a remedy to that violation. She offered him time, and she also offered him the opportunity to show what the prejudice was. And he was unable to do that. And I really think you have to look at the fact that since the defense theory of defending himself is just as viable with this evidence as it was without the evidence, that it doesn't matter. In the end, it didn't change anything for him. So, I think looking at it that way, and you have to say, she fashioned a remedy. He may not have liked it, but she gave him that opportunity. She said she'd give him time. She said she authorized the expert. He didn't ask for any more time when it came time for trial, and he did. Omar Felix testified, I think it was on a Friday. He hadn't even begun his case yet. So, and again, I understand the trial, the timing, and he shouldn't be interviewing witnesses after trial. I'm not arguing that. I'm arguing that from the time this was disclosed until the time he would have had to present his case, he had, at that point, the judge determined he would have had about 2 weeks to get that, to make that happen. So, because he didn't like her remedy doesn't mean that it's not appropriate. It just means he didn't like it. Did I answer your question?
Sure. Thank you.
Sure. And I guess I would agree with counsel on one thing, that the jury should have all the evidence in front of them. And again, remembering that exclusion of this is an absolute last resort. Exclusion of evidence is not looked upon favorably, especially when it's disclosed before the trial technically began. Admittedly, the Richardson hearing was conducted after the trial began, but the disclosure occurred the day before trial. So trial began on the 14th, the disclosure occurred on the 13th. He didn't ask for a continuance then either. Not saying it would have been granted, because they obviously had the jury pretty much ready to go, but he didn't ask for a continuance. And if this was If this was such a huge impact on his defense, surely he would have done so, and he did not. So I think looking at this from the standard of abuse of discretion, you have to say that the judge abused her discretion in fashioning this remedy and not excluding the evidence. And I don't think it gets to that. I don't think it gets to that level. Any questions on that? Or should I move to counsel's next issue? Moving to his next issue, which is issue number 14 about the jury not following the law. I think that's presumptuous. We have no evidence other than they didn't find mitigators, they didn't follow the law. And all the jury has to do is consider the mitigators, which they did. They were presented, but the jury isn't required to find them proven simply because the defense presented them. And when you look at the witness testimony, and a lot of the witness testimony that came in through the family members that had already testified in the trial, and I think we can all glean a lot from the transcripts if you looked at those about the attitude and the demeanor of those witnesses at trial. One, the judge went so far as to say that he had committed a fraud upon the court. These are the same witnesses that testified in mitigation. The jury found them to be essentially not credible with their testimony that they offered during trial. So the fact that they rejected that evidence in mitigation that's their option. They can do that. That's why the judge, who has a professional expert eye, that's the safeguard, is she also sat there and reviewed it, and she did find mitigators. So the fact that the jury didn't find them really is harmless, and that's within the purview of their determination. They're allowed to not find those if they don't find that they were properly presented. That's what they get to do. That's their job. So absent him saying they didn't follow the rules, that claim without any proof, we just don't know. We don't know what they did. We have to presume they followed the rules. They were given those. They are presumed to follow the rules and the instruction given by the court. And the fact that he didn't prove the mitigators doesn't mean that they didn't do their job. So, I mean, honestly, I don't think that there's any evidence in the record that the jury did not follow the rules with respect to the mitigators. I will throw this back to you if anybody has any questions on the other 13 issues. Sure.
Meditated aggravator?
With respect to both victims or?
Both, please.
Yes, okay. So looking, I think, at the evidence with respect to, I'll start with Collada. Was it not an emotional frenzy, panic, or fit of rage? And honestly, you could apply this to both Collada and Kyra. You have to remember that the defendant, came home from work. Well, first, let's back up just a little bit. I think we have to back up to the threat that came in that happened 2 days before Christmas, that Ms. Tarver testified that the defendant said, Kyra has one more chance to make me mad or bother Kamari, and essentially that she has one more chance. Well, so then on Christmas Day, somebody sees him with a weapon. So at some point, he's procured a weapon, a gun. So we have a threat. 2 days later, we have him obtaining a firearm. And then 3 days later, we have this incident. Moving to the day of the murders, the kids had this little dispute earlier in the morning before lunch. There were text messages that went back and forth about that, text messages between Mr. Joseph and Collada, the ultimate victim, phone calls, conversations between Collada and Ms. Denson about what had happened. There's evidence that the appellant, Mr. Joseph, got into a verbal altercation with his mom about this. So all of these things leading up to it, we have previous incidents between the kids. We have a threat that if it happens again, something's going to happen. She has one more chance to do something to Kamari. We have him obtaining a weapon. We have him arriving home from work that day knowing that this incident has occurred. The thing that he said, you have one more chance, it has happened. He goes into his bedroom. He has time to reflect. He has time to contemplate this. His mother says he was reading the Bible. But no matter what, he's in his bedroom, and he gets his weapon, and he confronts Collada about this incident between their two kids. We know that this happened, so we know that he planned this. We know it wasn't a rage. We know it wasn't a frenzy for a lot of reasons. First of all, he shot her 5 times, and we know she lived through at least one of those shots, but most likely the first 4. Because she was crying for help. He could have stopped. He could have stopped right then. He didn't have to continue, but he did. He ultimately fired the fatal shot with her. So there's definitely not a panic or fit of rage. This was very, very calculated. And I think we can look at it that it had to be calculated also because there were 9 people in that house, and the only 2 that were injured were the ones that were the object of his aggression, the object of his attention. And there was no immediate provocation there. When he confronted Collada, he was armed. He had that gun. So it's not like he went up to her and said, hey, can we talk about the kids? He went up to her and confronted her with a weapon. And when that discussion continued on, he shot her. So
You have a much stronger, heightened premeditation argument for the child because he chased after her, followed her outside and so on. So that's not a problem. But the first one, it seems like there was an argument and all of a sudden he started shooting.
Well, and I think that it was referenced as an argument, but I think at best you can call it a confrontation. What we know is that Collada had sort of stayed away. She was in her bedroom, and she was doing laundry. She was kind of away from the whole family activity, and we know she didn't have a gun. So obviously when there was this confrontation, and I think that means something because Collada didn't initiate this. We know that when there was this confrontation, he brought a gun to that fight. And he was the one that was mad. She wasn't. So I think maybe calling it an argument, maybe it doesn't matter, but he went looking for that with her. But I think the big thing is that he could have stopped. He made his intentions clear. He calculated this from the beginning. He said, I'm going to do something. This happens one more time, and it happened one more time. Moving to Kyra, which I agree with you, in order to get out of this house, she had to run by this incident. She had to know what was happening. And, I think this is a big point too, is as he's chasing her down, his brother tackles him. So he's tackled. He maintains his firearm. He doesn't hurt his brother. He doesn't shoot his brother. Nobody else gets injured in this fracas where the brother's trying to save Kyra. But what he does do is get up, extricate himself from this, keep his weapon, and continue to hunt her down. So he had every opportunity to stop. He had every opportunity to say, I just got tackled. What am I doing? But he didn't because he was on a mission. He had said, I'm going to do this. If this happens, this happened, and he did what he promised. So, I think that I know shooting deaths often are not, looked at this way, but he promised what he was going to do, and he did it.
The trouble I have with just that summation of the argument is that the same could be said of our decision in Richardson versus State in 1992 and others where some of the facts you've put together, an argument, obtaining a firearm, a confrontation, we've held do not alone get us to a cold, calculated, and premeditated showing. Now, I agree you've said more than the summation, and what you've said in addition to the summation, I think, does some of the lifting for you. But I guess the question I'm still left with is, can you identify what specifically takes us beyond just finding a gun, having a dispute with someone, and using it? Because I think that rule does prove too much.
Well, he didn't have a dispute, first of all, with Collada. Remember, his issue was with the children. So, he armed himself in advance. We know that. We know he got this weapon days before. So he had advanced procurement of this firearm. There was no resistance from the victims, none. They, for everything we know, were just innocent people in their own home. We have no provocation from either victim, clearly, we all know that. It was essentially an execution-style killing. There was no real emotion involved in this. So, I mean, I think, especially as it was pointed out, moving to Kyra, it doesn't seem like it could be any more planned out with her. And so, because she was the object of this threat. She was the reason that this threat came about. But I think that time frame makes it advanced premeditation. That time frame from the 23rd where he makes this threat, and then the 25th where we know he has a weapon, and then on the 28th he makes sure he has this weapon when he initiates this confrontation with Collada, who did nothing other than beg for her life. And even, you know what, even if we take it away with Collada, even if we take it away with her, we still have 8 other aggravators. So, I mean, in the big picture, it doesn't really change anything. I mean, that would be my argument.
Right. I mean, of course, we have to, make sure that we adopt the right rule with respect to each aggregator. So, I just want to make sure I understand the state's argument. I think I do.
Well, and I mean, I would look at Campbell, where that specifically says advanced procurement of the weapon, lack of resistance or provocation of the victims, killing, execution-style killing. It tracks those facts here, where, we know that he made a promise. If this happens, she has one more chance, and he kept that promise.
So this aggravator seems like it's the one that most consistently in our cases, to me at least, is kind of debatable.
Yeah, I agree.
What do you consider sort of the core of what this aggravator is getting at?
Well, I think looking at, we know it has to be heightened premeditation, not just premeditation.
Right.
But I think
it's unclear sort of what work these different words are doing, cold, calculated. I mean, the baseline for what you need for premeditation is so low that it just seems like we constantly in our cases kind of struggle to make this a true aggravator.
Sure, and there's crossover too. Obviously, some of the facts are going to apply to all 3 of them. Is it cold? If somebody's lying there begging for, somebody you live with, somebody who's invited you into their home is lying there begging for their life, yeah, I would say that's cold. Hunting down an 11-year-old child, I would say that's cold. So, I mean, I think the bigger one here is if you accept that the 5 days is premeditation, and I think, I think it is.
I guess it's the 5 day. I guess what arguably makes it trickier is that you did have this kind of it seems trivial, obviously, to someone who wasn't involved, but you did have this provocation. It wasn't like you had on day 1 there's a plan to kill, and then you sit there and wait and carry it out 5 days later. I mean, there was this incident that occurred, and I mean, it's at the end of the day, I think, as Justice Coriel was saying, that the relevance in this case for us is more just kind of articulating the rule. I mean, it's not something that would have a material effect on the outcome here.
Right.
But.
Well, I mean, if we look at just general premeditation, we all know that can happen just an instant before the crime is committed. So this premeditation, even if it was hours before, it's still advanced. I mean,
I guess though, but that gets to the whole issue of what aggravators are for. I mean, if the point of the aggravators in the context of the overall death penalty scheme is to kind of separate the worst murders from it seems it's horrible to even talk about murders as being more, you know what I'm
Yeah,
saying?
I do know, yes.
But, so just barely, getting over the sort of minimal baseline for premeditation is a matter of semantics. Obviously, I know that it might do that, but whether it satisfies what an aggravator is supposed to do is kind of a separate question.
Well, I think that when you have this kind of premeditation directed at an 11-year-old child, I think it gets over.
Right, and then obviously you've got the HAC here too, which,
Yes.
relates to that.
Yes.
so.
And again, that's why I pointed out, even if you take it away with the first victim, with Collada, you still have 8 others to fall back on. But, my argument remains exactly the same, that it satisfies both of those, heinous, atrocious, cruel, and cold, calculated, and premeditated. Any other questions you'd like me to address? Any of the other 13 issues? No? The state then respectfully requests that this court uphold the appellant's judgments and sentences from the lower court. Thank you.
Rebuttal.
Yes, Your Honor. I'd like to address just a few things. The last one that, we had 8 other aggravators. Let's not worry about the one that we should have never instructed the jury on, and the jury heard instructions that made the defendant out to be something worse than he was. So that's why you don't give jury instructions to jurors that don't pertain to the case. That's why you have an instruction conference, and I'll stick with all my, I'll rest on the brief and the rest of that, but the argument that no, it's okay because we have all the other stuff, it taints the jury.
No, but I mean, counsel, to be fair, she made a pretty compelling argument about why it would satisfy the test, and she's obviously just sort of saying, as anyone would, that even if the court disagreed with her, that it wouldn't have affected the outcome. But I mean, do you want to respond to what she said about,
My position is we don't know if it would affect the outcome of the...
No, but can you respond to why the cold, calculated, and premeditated wasn't met, given the factors that she just discussed?
I believe it was improperly given, and I would rest on what I said in my brief regarding that, Your Honor. And as to the gun, we know little or nothing about the gun. The time frame that the state has laid out, I don't believe is backed up by the record. The gun was never recovered. We don't know where the gun came from. We don't know where the gun went. So I would say that plays against her argument that this was all a premeditation. And as to the statement that was made 2 days earlier by an adult to a child that you have one more chance, he didn't say, I'm going to kill you, you need to do this, you need to do that. Any adult who said to a child, you got one more chance, or you need to behave, that statement should never have come in. It was irrelevant to this case, and I'll rest on my brief as to why it was irrelevant, but it should have never come in to this case. Excuse me for removing my glasses, I can't see both. A review of this whole transcript, it makes it clear that the trial judge was moving on with this trial. She didn't say she was going to slow it down for me to go find an expert. She didn't say that, she did say I could use their expert. I never said there were no experts that were available. There were no experts that I could find at that point. I was court appointed to this case, which meant I have to go by the JAC. As Judge Labarga pointed out, the sheriff's office, on the other hand, has this budget and they can do whatever they want. I have to get permission. I have to find a witness. I have to find a witness who's willing to do it under the cost of the JAC. So no, this wasn't just a, hey, he could go in 2 weeks and find somebody. There was no witnesses available under the time frame that the judge put in place here. It was real clear that the trial judge was moving along with this trial. And the last thing I'd address is the state keeps saying that exclusion is the least remedy we should do. Exclusion is frowned upon. We should never do exclusion. Well, that's what the state knows the law is. So if the state knows that's what the law is, and you present a witness at the last minute, knowing that the court's not going to exclude the witness, it gives the state a benefit for knowing that the witness isn't going to be excluded. As Judge LaBarga pointed out, this Richardson hearing took place after the jury had been sworn. This witness should have been excluded. It was compounded, the error, by not permitting a full examination of his testimony by the judge on her own motion, cutting it off. This was not harmless error. The court should overturn this conviction, overturn the